Are you sure?
Here's the 30-second lesson on what legends know. Never ask a bride why she's getting married. Don't wear a skirt on a windy day. Deodorant is not a shower. Don't sniff chili flakes. And don't forget, saving is not investing. Legends don't just save, they invest in mutual funds. Mutual fund investments are subject to market risks. Read all scheme-related documents carefully.
Lined up naked under the ferocious light of the midsummer sun, the men of Rajasthan's Mongia Bay village stood silently as the police examined their genitals one by one, searching for cuts and bruises. Earlier that day in July 2018, police search parties looking for a missing 7-year-old girl had found her body tossed into the scrubland, the earth dyed with her blood. Finally, one teenager was pulled out of the crowd. The inquisition in the village schoolyard ended, giving way to a criminal trial that would see farm labourer Kamal Lodha sentenced to life imprisonment for rape and murder. As rage sweeps over the country over the rape and murder of a trainee doctor in Kolkata, Lodha's trial seems like a model of the fast, effective justice that protesters are demanding. Except there is for one disturbing fact. Forensic investigators were able to recover DNA from the body and clothes of the victim in Mongia Bay, but neither matched with the man who is now in prison. Witnesses lie, DNA doesn't. Though Indian politicians have come to excel in expressing outrage against sexual violence, they've done little to equip the criminal justice system to address it. There's never been a national audit of the state of police preparedness to investigate sexual violence. What there is a steady drip of damning revelations. 12 years after the rape murder of a physiotherapist in New Delhi catalyzed massive protests, it's clear the criminal justice system remains depressingly under-resourced. Ludhiana hospitals have been complaining they don't have cheap, easy-to-use rape evidence collection kits. Tests in Haryana are held up because there are no DNA testing kits. Labs have often been sent reports 10 days after they were taken, sometimes rendering them useless, and forensic laboratories across the country are backed up with cases pending months, even years. Legislation introduced after 2012 hasn't helped either. The conviction rate is stubbornly stuck at 30%, just half of that in the United Kingdom. We have no way of knowing whether the suspect held for the Kolkata case is innocent or guilty. But the case of Lodha gives us reason to seriously question if justice is actually being done. From its beginnings in the 19th century, modern police largely ignored violence against Indian women by Indian men, seeing it as an issue that involved custom and the family rather than the state or law. The rule of colonial indifference, the historian Elizabeth Kolsky has called it. Following the 18th century English legal theorist Matthew Hale, colonial judges worked from the presumption that women often consented to sex but then lied about it. False charges are constantly made and easily proved as rape, Judge D.I. Mooney lamented in 1857. In one 1851 case, a judge held it was impossible for a healthy young woman to be raped by a drunk man. In other cases, Kolsky writes, women who brought rape allegations found themselves being tried for adultery instead. The burden of misogyny fell most heavily on the poor. In 1907, when the Kathiawar Chief Court heard the case of Bai Galal, an itinerant beggar who was dragged from a temple platform and raped by two men, it chose to disregard eyewitness testimony as well as injuries to her body. I am compelled to think that with people of this low class, the judge explained, such slight injuries are explicable other than by violence. These attitudes entrenched themselves in the post-independence criminal justice system. The text relied on by generations of Indian criminal justice officials, Jai Singh Modi's medical jurisprudence, asserts that proof of rape requires victims to demonstrate that they used every means such as crying, biting, beating to prevent the successful commission of the act. False charges of rape may be easily set up by girls at the age of puberty, another standard textbook published in 1963 claimed. Girls often enough invent attacks by quite unknown persons, or graver still, they bring false accusations against persons named. These values drilled into our judicial system. In 1977, the Supreme Court acquitted three men accused of raping a pregnant woman in Odisha, saying that she should have done more than just shout for help. When evidence was irrefutable, judges went to extraordinary lengths to excuse the actions of perpetrators. In a 1978 judgment, the Supreme Court reduced the sentence of a rapist from 4 years to two, arguing that, and I quote, a hypersexed Homo sapiens cannot be rehabilitated by humiliating treatment. The court suggested the crime was in part extenuated by new sexual mores, including lascivious dating and mating by unwed students. Lodha's case, at first glance, appears to suggest the attitudes of the criminal justice system have finally broken away from this dishonorable past. The story, though, when you get to know it better, gives no reason at all for such comfort. Framed by former Chief Minister Vasundhara Raje Scindia's election campaign in 2018, the Mogia Bay case involved unusually high political stakes. Local police, conscious of the potential fallout on her campaign, pushed hard to make an arrest. An investigation by journalist Abhay Lakshman showed that authorities tutored witnesses to suggest Lodha had just been seen with the victim before she disappeared. The charges against Lodha were filed in just 10 days, 8 full weeks before the DNA forensic tests even became available. Those tests, documents seen by ThePrint show, cast substantial doubt on Lodha's guilt. Experts at the Jaipur Forensic Sciences Laboratory concluded that the DNA found from the victim and her clothes belonged to two separate men, but neither of those two men were Lodha. The semen from one of those men had somehow made its way onto an underwear where Lodha's semen was also present. This was pretty strong evidence of some crude evidence tampering. Even medical evidence of Lodha's age was carelessly dealt with. School records suggesting he was a minor at the time of the crime, for example, were dismissed on the basis of x-rays and a medical opinion from a doctor. But that doctor had no qualifications in radiology. Lodha was convicted anyway in September 2019, trial court records show, with no discussion at all of the DNA report. The legal aid counsel provided to him, it's possible, might have misunderstood the significance of what the FSL had found. It wasn't argued either in Lodha's appeal to the Rajasthan High Court, nor in the Supreme Court, which upheld the conviction but sent the case back to Jaipur for reconsideration of the life sentence it had awarded him. Lawyer Nitin Jain, who represented Lodha during this second round of High Court hearings in 2022, finally noticed and raised the DNA issue. Appalled, the bench of Justices Pankaj Bhandari and Anup Kumar Dhand ordered the police to reinvestigate the case. This judgment, though, was reversed the same year, with the Supreme Court rebuking the High Court for addressing questions of fact which were not sent before it for consideration. Lodha's revision petition was dismissed briefly in 2023. Even though the Supreme Court might have legal reasoning on its side, it's left open the question over the facts which actually put Lodha in prison. There is good reason to suspect, therefore, that neither Lodha nor the victim or her family have received justice. 50 years ago, the Supreme Court's acquittal of two police officers charged with the rape of an Adivasi woman ignited a feminist rebellion against sexual violence. To governments, to the judiciary, to the police forces, the women's movement posed a deep challenge. The state's legitimacy as a guardian of women, as an institution of patriarchy, came under assault. The justice system responded to these new pressures by using the same tools routinely unleashed to solve other kinds of crime. Torture, planted evidence, dubious witness testimony, we all know the story. The police officers alleged to have executed 4 rape-accused men in Hyderabad, beaten a suspect to death in Jaipur, or the prisoner found hanging inside a cell in Kashmir. Each of these were victims to a criminal justice system flailing in the face of demands for gender justice. Like all other complex crimes, rape is difficult to investigate and prosecute. The eyewitness testimony of the novelist Alice Sebold and junk forensic science led to the wrongful incarceration of her alleged rapist for 16 years. 5 teenagers wrongfully accused of raping a jogger in New York Central Park, the case that launched former President Donald Trump's political career, by the way, even confessed to their crimes, though DNA evidence eventually proved their innocence. Even in highly resourced police systems, sadly, a large number of rape perpetrators are never identified, although new forensic techniques are enabling some cases from decades ago to be solved. The trial and punishment of rape have ultimately been about upholding the honor of men, not justice for women. The treatment of rape suspects like Lodha is intended to show that patriarchy does, after all, work and will deliver. This, however, is judicial lynching, not justice. I'm Praveen Swami, and I'm a contributing editor at ThePrint. Thank you for watching this episode of Security Code.